Amid tight security, Troy Davis arrived at the federal courthouse. Inside, it was a much different defendant. Davis is now 41 years old. His defense team trying to prove he was wrongly convicted and should not be put to death.
A case such as Troy Davis's could go through the system time after time after time, and the procedural process would be more important than this person could die for something they didn't do.
Once a person has been convicted, it is very, very difficult for them to overturn that conviction.
The appeals process is not designed to retry a case. The appeals process is designed for the defendant to have an opportunity to say there are specific errors, constitutional errors, that occurred during that trial. The criminal justice system is not designed to do the right thing. It is designed to do the correct thing, correct according to the procedural process. There's this idea that if we start trying to figure out what was right to do, what the moral thing is, we're going to clog up the system and the whole thing will fall apart.
A person is presumed innocent until they're convicted of a crime. Once a conviction occurs, however, the presumption of innocence as a legal matter vanishes.
Troy Davis has lost the reasonable doubt standard and now must really climb a very, very steep, if not impossible, mountain to overcome his guilty conviction.
The convicted defendant has to show that no reasonable person could reach the verdict they reached, could decide that he was guilty beyond a reasonable doubt.
We do not have a process in place to test the accuracy of those convictions.
So the minute that verdict is entered, there's a much higher burden on the defendant going forward.
The burden has now shifted to him.
Troy Davis's case also illustrates how difficult it is when a defendant presents a claim of actual innocence based on new evidence to get a hearing on that evidence.
Part of the problem with Troy Davis's case all these years is that, he found the evidence sort of too late to meet the statutory limitations.
And even when that hearing is had, how high the standard is for a defendant.
The U.S. Supreme Court granted Davis's request for a new hearing, meaning a Georgia federal judge must now decide if there is enough new evidence that wasn't available at the time of the trial to show he is innocent.
The federal district court used the standard clear and convincing. He had to prove with clear and convincing evidence that no reasonable juror would have found him guilty.
The problem establishing innocence as a matter of proven fact is a much more difficult problem to solve.
The judge focused the hearing on the wrong question. The question to me is there reason to believe that the conviction in this case was reliable? And the question that the judge was interested in was, can Troy Davis produce clear and convincing evidence that he was innocent? And those are two different questions. And after 20 years, and after witnesses have died and memories have gone stale, proving the negative, proving that a person is innocent is very difficult.
And so even though he has these recanting witnesses, it's not enough.
4 witnesses who testified at the original trial came to federal court. Some say they were intimidated by police to name Davis as the killer.
I haven't seen any cases in my experience that has the number of recantations that he has.
The judge chose to believe law enforcement witnesses who testified that improper questioning did not occur, that coercion did not occur, and he chose to disbelieve witnesses who testified that coercion did occur and that they didn't testify truthfully at the Davis trial out of fear.
Collins testified Wednesday he was just 16 at the time of the murder and that police had threatened to name him as an accessory if he didn't say Davis was the killer.
And that fear is a real factor in criminal trials. This judge chose to ignore it.
The defense also submitted affidavits from 2 witnesses who have died since the original trial. Both recanted their testimony. Charles Hargrove also testified that Coles told him he'd killed McPhail and that Troy took the fall. One man, Benjamin Gordon, said he'd been beaten by police the night Officer McPhail was killed and told, "Just say Troy did it." Gordon then testified that another man, Sylvester Red Coles, had confessed to him in 1996 he had killed McPhail. Gordon said it needs to be made right because another man is on death row.
Benjamin Gordon is a relative by marriage of Red Coles, and he's come forward to say that he witnessed Red Coles shoot Officer McPhail. In making that identification, Mr. Gordon explained his delay in coming forward by saying that he didn't want to testify against Mr. Coles because he's a relative, and also because he was frightened of Mr. Coles.
Benjamin Gordon, I believe, was 16 at the time. Red Coles, according to virtually every witness, was a dangerous, feared character, and he says he did not come forward for all these years out of fear.
He's been alienated from his family as a result of his testimony against Mr. Coles, and he's also reported being harassed.
If you believe Benjamin Gordon, then you believe that Troy Davis did not shoot Officer McPhail. So he could prove it, but only if Judge Moore believes his witness. Judge Moore found that not credible. In his order, Judge Moore, he said the case against Troy Davis is not ironclad. Now, Judge Moore also said Troy Davis is not innocent. I frankly am not sure what he meant by that. I think he may have meant Troy Davis did not, in this proceeding, establish innocence. He did not prove his innocence. I note he did not say Troy Davis is guilty.
There's no reason to believe, based on the record that was produced at the evidentiary hearing and based on everything else that we know, that Troy Davis was guilty.
I think most Americans think the death penalty, if appropriate, is appropriate when the case is ironclad, when we're really, really sure.